The guarantee of basic rights in Canada has a pretty charged political history. The first major attempt at a Bill of Rights came in 1960 under Prime Minister John Diefenbaker's Conservative government. A decade earlier, Diefenbaker had given a speech on the need for a Bill of Rights to take a, quote, forthright stand against discrimination based on colour, creed, or racial origin. While the bill was well-intentioned, Canada didn't have power over its own constitution yet, which was a British Act of Parliament. So all the federal government could do, without a lot of provincial support, was pass a federal act called the Canadian Bill of Rights. This had no impact on provincial governments, and as a regular law, it was largely up to the federal parliament to revise earlier laws to conform to it, and theoretically any future federal government could just unilaterally alter it as well. Even Diefenbaker said the lack of provincial support for the actual constitutional changes meant the bill had limited practical impact, but it still helped set the stage for bigger movements later. The 1960 Bill of Rights is technically still in place today, though it has largely been superseded by the inclusion of the Charter of Rights and Freedoms in the 1982 repatriation of the Constitution Act, which gives it proper precedence and protection from federal and provincial laws, notwithstanding the Notwithstanding clause, which is a whole different subject.
Today I want to talk about Section 33 of the Canadian Charter of Rights and Freedoms, which is also known as the Notwithstanding clause. Now, for my Canadian viewers, this may be a little surprising. For my American viewers, this may blow your minds, because this is a really strange thing, and it's been described as uniquely Canadian, which is not always praise. So what does the Notwithstanding clause do? Well, that is Section 33 here. So, Parliament or the legislature of a province may expressly declare in an act of Parliament or of the legislature, as the case may be, that the act or a provision thereof shall operate notwithstanding a provision included in Section 2 or Sections 7 to 15 of the Charter. And they also go on to say, an act or provision of an act in respect of which a declaration is made in this section is in effect shall have such operation as it would have but for the provision of this Charter referred to in the declaration. That's really dense legal language. What does that mean? Well, it means that the government, and that's either the federal government or a provincial government, can declare that a piece of legislation or an entire act applies even though it violates the Charter. They can say, listen, we know this violates these sections of the Charter. We want it to apply anyway. And when they do that, it basically applies as if those sections of the Charter didn't exist. You might be thinking, wow, what limits do they put on this power? And really, there's only one limit, and that is that it shall cease to have effect 5 years after it comes into force, or on such earlier date as may be specified in the declaration. So the longest that can last is 5 years. The idea being is that there needs to be an election in between when this is put forward and when they want to renew it. So, the next thing we need to know is what provisions does it allow the government to ignore? That's Sections 2 and Sections 7 to 15. But before we get there, we should actually have a look at Section 1. The reason why is that Section 1 is a big limiting clause to all rights in the Canadian Charter. And it says that the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. So, these rights only apply subject to limits. The government can actually say, listen, we want to limit your freedom of expression so long as it's a reasonable limit that they can demonstrably justify. The test for demonstrably justified is actually super low. They don't really have to show much in terms of evidence as to why it's needed. This is a giant sort of escape clause already built in. So why would they need Section 33 given that Section 1 is there? Well, they might want to do something that is not a reasonable limit, that's an unreasonable limit, or that they can't demonstrably justify, which again, real low standard. They basically have to say that they're concerned that a harm might happen and they don't have to be crazy about it. So, it's Section 33 is really there for when the government wants to do something crazy and unreasonable. And let's see what sort of crazy and unreasonable things they can do. Well, they can suspend Section 2. Everyone has the following fundamental freedoms: freedom of conscience and religion, freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication, freedom of peaceful assembly, and freedom of association. These are declared to be fundamental freedoms in Canada that the government can only infringe if it's a reasonable limit or if they just declare that they're infringing it. So think about this. They can say, you no longer have freedom of religion. We're putting a bill through and we know it's trampling your freedom of religion. We're doing it anyway. Or freedom of thought or belief. I agree that those are fundamental freedoms. I don't agree that they should be able to just turn those off if they become inconvenient. Let's look at some legal rights, because that's where it kicks in again. Everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. So they weren't trying to get rid of jail cells, but they were trying to say you only end up in a jail cell if you have done something, wrong, something where you have been convicted of a crime in a fair trial. Well, they can turn that off if they want. Right to be secure against unreasonable search and seizure. Right not to be arbitrarily detained or imprisoned. Right when you're arrested or detained to be informed of why and to retain and instruct counsel. There's some even bigger ones in there. The right to be presumed innocent until proven guilty according to law in a fair and public hearing by an independent and impartial tribunal. That's kind of a big deal. Not to be denied reasonable bail without just cause. Not to be found guilty on account of any act or omission unless, at the time of the act or omission, it constituted an offense under Canadian or international law, or was criminal according to the general principles of law recognized by the community of nations. So what does that mean? Well, let's say today you possess marijuana in Canada, and right now it's legal to do so within certain restrictions. But let's say you get a future government who is really anti-marijuana, and they don't want to just punish people who possess marijuana going forward after they've banned it. They want to punish all the people who possessed it during the time, right now, where it's legal. So they want to make a retroactive law that punishes people for possession of marijuana back when it was legal. The charter says you can't do that unless they want to. Which is, think about what this means, right? The fundamental, essential thing here is that you should know that if you do legal things, you're not going to be punished for them. That a future government can't say, listen, not only do we want to ban guns, but we want to throw people in jail who had legal guns. This is such an essential, critical right, just to be able to rely on the thing that I'm doing is legal, and therefore I won't ever be punished for it. That it's shocking that they can say, nah, we're canceling that. Everyone has the right not to be subjected to any cruel and unusual treatment or punishment. This is the section of the charter that they often refer to, for instance, if the police decide to lay a beating on you. You'll argue that that violates your rights under Section 7, which they can, again, infringe, and Section 12. And here, this one just makes me shake my head when I think about it. A party or witness in any proceeding who does not understand or speak the language in which the proceedings are conducted, or who is deaf, has the right to the assistance of an interpreter. So let's say you are a deaf Canadian, and they've charged you with a serious offense. Let's say they say that you've murdered somebody. If they decide that they don't like to, and they pass a law invoking the Notwithstanding clause, in theory, we could have a trial run for that individual where they're not able to know what's going on. Defense lawyer and Crown are making arguments, and they don't understand them because there's no interpreter. The judge makes a ruling, and they don't know what the ruling is because they don't have an interpreter there. The idea that this is theoretically possible under Canadian law is startling. Get comfortable with this, because the real big concern I have, let's say we let governments start doing this and it becomes routine. Well, what rights are we going to have left if we let governments start basically opting out of all of these critical, essential rights? Because we're talking about fundamental, essential rights. If the government wants to step on those, that shouldn't be easy. In some cases, it shouldn't be possible.